functioning justice system is vital for a democratic system of governance. Its essential contribution is to foster a peaceful and orderly society while balancing the protection of the community with safeguarding liberty and freedoms of individuals. In Kenya, the institutions serving the chain of justice have previously been viewed as not being independent enough to expeditiously administer justice for all without discrimination. However, since the enactment of the new constitution, the justice system has been undergoing transformation, and one of the remarkable visions in its transformation is the idea of having a coordinated approach by the actors in the justice sector, which is driven through the implementation of Court Users Committees, CUCs.
CUC is actually the abbreviation for Court Users Committees, where the users of the court services come together and have a conversation. We have the police service, we have the DPP, Director of Public Prosecutions, we have prisons, and of course we have the courts. The Court Users Committee now brings all these public sector agencies and also non-state agencies to ensure that we are offering services, having knowledge of what each other is doing. So how can the members of the public participate in this forum? They can approach the CUC either through a representative institution like religious organizations or civil society or professional bodies, and then they can present their views or present their request to the chair of a particular CUC in any particular region of this country.
Before the inception of CUCs, departments within the justice system acted in isolation, and the judiciary was blamed for the failings of all the justice sector actors.
Court User Committees started way back. The discussions around that time when they were formed was at a time when the public's confidence in the judiciary was at its lowest ebb.
The blame game across the different agencies and departments of justice sector became the order of the day. Cases delayed and the backlog continued to rise, clearly confirming that justice delayed is justice denied.
All the blame was going to the judiciary. So we thought that it is time that we apportion blame where it was necessary. Secondly, it is time that these people, all these actors at every level, were able to be accountable to each other. We wanted the police to be accountable for what they do, the judiciary, the respective judicial officers to be accountable for what they do, and we also wanted the institution of the judiciary to be accountable for what they do to ensure that we are provided with the necessary tools.
Section 35 of Judicial Service Act institutionalizes CUCs by providing for the establishment of the National Council on the Administration of Justice to ensure a coordinated, efficient, effective and consultative approach in the administration of justice.
NCAJ basically provides oversight and encourages the coordination of justice sector agencies. We use the analogy of the justice chain. A chain is only as strong as its weakest link, and therefore we have to help each other. Our fate lies in our interdependence, and our successful interdependence can only be realized if whatever it is that hampers one institution is sorted out so that it doesn't affect the operations of the rest.
CUCs have now been established in almost all court stations countrywide, and some have adopted very innovative approaches in dealing with local challenges. In Naivasha Law Courts, for example, the CUCs have made great strides with monitoring case backlog, especially in criminal cases. The Chief Magistrate, Honorable Gedinji, says his CUC is transforming the station, especially with the recently established court wardrobe.
We realize as a committee, some of the people who are charged in our courts stay in prison for some times, waiting for their matters to be concluded. They are not seen there by their relatives. Since they are suspects, they are not given uniforms by the prison department. Their clothes gets worn out. Instead of them coming to court in worn out clothes, we decided to open a wardrobe that is running well. So when they come to court, they make an application, or the magistrate can find out that there is a need for assistance and make such an order in the file, then they are assisted from our wardrobe.
As part of their arrangements, the CUC members in Naivasha visit various institutions for acquaintance. Recently, they visited both Naivasha medium and maximum prisons. The idea is to see for themselves the condition in prisons and give remand suspects an opportunity to put the questions to the right parties, either to the police, to the prosecution, or the magistrate.
Another thing of the court users committee is that they help in the congestion of the prisons. Of course, we have what we call mobile court. They come inside, they hear the prisoners plead themselves one-on-one. So then you find out of their arguments, their bonds are lowered, you see, because they can argue out themselves. And then out of it, then we also see how we can assist each other. Instead of shifting blame, saying the congestion is because of the prisons, because of the police, because of the judiciary. So when we meet like police, they hear their challenges. We also hear our challenges and also the judiciary. So out of it, you find administration of justice is done faster.
As a way of strengthening their working relationships, the CUC members in Naivasha have started a reforestation program. This is an activity outside the court but unites them and sets a good example to the public. All the members plant at least one tree. The sky is the limit for Eldoret Court Users Committee led by Honorable Charles Mbogo, the Chief Magistrate. The members have been able to form task forces to deal with various challenges such as street children and gender-based violence in the area.
What we did was to organize several trainings. We trained judicial officers, prosecutors, members of the provincial administration. We were also able to hold public meetings with the members of the public to sensitize them on how to handle SGBV cases. As a result of that, we saw a rise in the number of cases that were brought to the law courts. We also saw an increase in professionalism by the investigators regarding such cases.
Chief Inspector David Molly, the officer commanding Station Eldoret, says CUC has made his work and that of the police much easier.
Sometimes you may not know whether you are doing something bad to some other people, but whenever we meet and the court points out that you, the OCS or the police in general, you are delaying prisoners, or you are staying with the prisoners for they are staying for overtime. Rather, they are exceeding the 24 hours. Sometimes we get pushed by the court, rather the CUC, and they point out your weak point. When it is pointed, you must do something.
The members of the public are well represented in court users committees. This includes religious groups' representatives and human rights activists.
So our stake within the CUC actually is to make sure that as the courts play their role as administrators of justice, it's human rights based. And it follows all the tenets of the law. Like you see, when a matter is in court and it has there are some unjustifiable adjournments, we bring to attention of the CUC. And because this affects the common mwananchi, whom now as a society organization we represent within the CUC.
Contrary to the public view of the judiciary as an isolated ivory tower, court users committees are changing that perception and bridging the gap between the judiciary and the public. For instance, the Court Users Committee in Makadara recently held a community outreach forum in Kayole suburbs. The idea is to interact with the public, know their problems, and see how best to solve them.
Now we are people-focused. We do not see people as accused. We now see them as our customers. They are customers that are coming to consume the service that we offer, and that is to help them resolve the disputes. Resolution of dispute is the major thing that we are involved in. So it is a transformation. It is in our transformation framework, and I think this is the way to go. Get to the people, let them understand you, and help them understand how the court system works.
This community outreach forum has benefited the people by educating them about the courts. Some of those who attended the forum said they usually find it hard to report their cases because they think it's a waste of time and no one would hear them.
Nimekuja leo kujua ni nini inaendelea sana mahakama. Mpaka saa hii tumefika, nimeelewa vile wanafanya kazi. At times kwa mfano venye utasikwa, kuna siku unafaa ukae kwa remand, usiwekwe sana. Sasa unajua kama singekuja singejua sana.
Reducing case backlog in court is a major problem the CUCs are trying to address. One way of dealing with this is by encouraging people to use alternative dispute resolution mechanisms which conform to the law, and the parties have to agree to it.
We encourage, particularly where there are minor offences, that people can reconcile. We encourage ADR, for instance, minor assaults, and even land cases, for instance. There are some of these cases which involve boundaries, and mostly some of them involve relatives. And although they have the right to come to court to ventilate their various claims, some of them are matters that can easily be solved at home.
Court users' committees remain the best vehicle for improving public participation in judicial processes and for the speeding the wheels of justice. It is hoped that people will work together to realize the seamless administration of justice.
We need to use the CUCs as the entry points for getting the communities to support what we do. So it means treating people seriously and humanely, particularly magistrates who meet the ordinary people every day. It's very, very, very critical. You are the foot soldiers of the judiciary.
The service delivery for the Kenyan people must always remain our shared vision.
I think the CUC concept has been the greatest idea the judiciary has ever incepted.